All right, the next case on the docket is RIVERA versus PURTELL. Fire when ready.
Morning.
Good morning.
May I please support Kristen Mitchell, counsel for the appellant Jason Rivera?
Is 5 minutes fine on rebuttal?
I'm sorry, I'm having
Is
a
5 minutes sufficient?
Yes,
All right.
thank you.
Okay, go ahead.
So we're here because the trial court granted a motion for new trial in a child custody proceeding, a paternity action, where the father was awarded equal time sharing until the minor child reached kindergarten age. When the child reaches kindergarten, the child will spend majority time share with the father.
Did the trial judge misread Arthur versus Arthur in your view?
I believe so. I believe Arthur specifically applies to relocation cases, whereas the standard for child custody determinations is best interest supported by substantial competent evidence. Sorry, I'm really hot and nervous. Okay. So there are two cases, one in the first district and that's one of the cases that the trial judge used to support her determination, the JP case, which didn't need to expand Arthur because there wasn't substantial competent evidence to support that conclusion. All the factors in that case, 6 of them went for the father, 1 of them went for the mother, and then the court decided 5 years later that it was going to change custody, or maybe 4 years because it was a first grader at that time. Where Crift v. Openauer, 4th DCA case, says no, it's permissible to change.
Well, JP did extend Arthur, right? I mean, there were a couple holdings in there in the court's reasoning.
In Crift?
In JP.
In JP, their first reasoning was that the evidence didn't support it.
Well, they applied Arthur outside of the context of relocation.
I believe the second factor was that they said specifically Arthur, but it wasn't relocation because it was a change in the residence of the child, not the parent.
Right,
So
but yet they still applied the Arthur concept there.
Right, correct.
So if we were to follow JP in this case, would that not require an affirmance?
It would, but in Crift, that's the same exact scenario also because the child, the parents stayed in their residences. It was just the child went majority of the time with the father in Crift v. Openauer.
Well, in Crift, I don't think there was any, there was no part of the judgment that said, but if one parent moves, then this, right? So that's different in this case.
Right, that is somewhat different, but the cases that deal with the allowing or requiring is what the cases deal with, requiring a parent to move.
Do you think it makes sense from a policy perspective to apply Arthur in a context other than relocation?
I do, yeah, and a relocation.
But then we ought to affirm. If it makes sense, then the trial judge did what the trial judge should have done and was right, and so we're done.
I'm sorry, Your Honor, this isn't a relocation case, though.
I understand that, but I asked you, the question was, does it make sense to apply Arthur in a context outside of relocation, and you said yes.
I'm sorry, I missed the outside of relocation. I just heard in the context of relocation. No, it doesn't. It just makes sense. It does and it doesn't.
Why not?
Because trial courts are tasked every day with creating a parenting plan that's going to last until a minor child reaches the age of majority or there's a substantial material change in circumstance. That gives deference to the res judicata effect of the original final judgment.
And were there portions of this final judgment that made prospective determinations that were not challenged?
I believe they challenged the school designation.
Right, but that was only one of a few, wasn't it? Weren't there other prospective decisions made by the trial judge that weren't challenged?
Yes, I mean, in that there's the summer schedule, there's the holiday schedule. I mean, trial judges all the time are tasked with looking prospectively, to a certain extent, when creating parenting plans. I mean, if you go to trial in September, is a parenting plan that establishes the next year's summer timeshare to prospective, is that not allowed under Arthur? I don't think that's what the Supreme Court intended. And if you look at the language of Arthur, it specifically says in relocation cases. I mean, every time it says it, it modifies it in relocation cases. So I think that the court improperly applied Arthur to the facts of this case. I think Crift got it right in that if there's substantial competent evidence to support it, the best interest of the minor child, then it should be affirmed.
Okay.
And then in addition to that, I'm sorry.
Okay.
In addition to that, if it is true that Arthur should apply to the normal parenting plan context, then why would they need a new trial? Wouldn't we just remove the offending provisions? I don't think that it is true, but if it were, isn't it still prospective? Either way you look at it, if we're taking kindergarten into account, kindergarten doesn't happen for 2 years, they still wouldn't be entitled to a new trial.
All right.
Unless there are any further questions,
Okay.
that's,
All right, then we'll let you reserve the rest of your time for rebuttal.
thank you.
Thank you.
Good morning, Your Honors.
Morning.
David Roberts here on behalf of the mother, Shannon Purtell. If it pleases the court, may I proceed?
Sir.
Thank you. I do not agree that Arthur was incorrectly applied. I think that Arthur...
Well, counsel, what about the summertime? I mean, changing the plan for summers, why is that not a prospective analysis that Arthur would prohibit?
I think that there were several issues in the final judgment like that one that Arthur would apply to.
I think the question being asked is, does it make any sense? I mean, let me give you this hypothetical. You've got a child that is 6 months of age. And so the trial judge is going to make a determination as to, doing parenting plans, right?
Right.
Required by statute. They must do that. And so the trial judge says, well, the first summer the child's going to be 10 months old, and so we're going to give the father 1 week, and then when the child turns 5, we're going to increase it to 3 weeks. When the child turns 10, we're going to split the summers. Under your analysis, that's completely improper. Right?
Not necessarily, Your Honor.
Well, wait a minute. Either it's one or the other. Either you can do prospective determinations or you can't. That's your argument. Your argument to this judge was Arthur prohibits prospective determinations, and either it does or it doesn't. Right, Mr. Roberts?
That's correct, but may I expand on that a little bit? So all relief in these final judgments in family law, it's always prospective. In other words, it's always going to affect the parties in the future. The difference in this particular case is that there were conditions precedent outlined by the court, by the trial judge, like the fact that my client would have to move within 25 miles.
That's not what it... I'm sorry.
Go ahead.
That's not the way I read the judgment. It simply said that if your client were to live within 25 miles, then the parenting plan would be different. It doesn't say she has to move.
I agree with that. However, the time-sharing schedule was an alternative schedule that tied into condition precedents that were associated with future events that would or could occur and the court didn't know how those events would play out at the time. All relief in family law, everything that we say.
What was the future event?
Pardon me?
Are you talking about, what future event were you talking about? I'm sorry.
The future event would be, well, two things. Number one, there's actually two things. Number one, that the child would move to Fruitland Park, up near the Villages, out of Orlando, where the child was previously. And number two, then in order for...
Wait a minute, that was the initial determination, and the trial judge is required to make a determination as to whose residence will be utilized for school districts, right? Under the statute, they've got to do that.
Yes.
And the evidence in this case was that the mom had moved on 5 different occasions, and the father had a stable residence, and so the trial judge utilized the father's stable residence as opposed to the mother's residence. So that, that was a determination that the trial judge was required to make by statute. How can that be one of the things you're going to point to for prospective conduct?
The trial judge could have and did and could have ordered the school district based on the events known at the trial. The problem is that what the trial judge didn't say that the child is going to stay with the father forever. That was one of the possible outcomes. That's not what occurred. What occurred was that the parties were going to do 50-50 until kindergarten, and then something else would happen. And that's the problem with the case.
Well, I mean, kindergarten is pretty much a known fact that the child's going to go to kindergarten, right? It's the law, right?
That part is known, Your Honor, but what's not known is where the party is going to live at kindergarten. Is the father even going to be in Fruitland Park? What's the school going to be like in 2 years in kindergarten?
I'm sorry, but that I don't understand that argument at all. I mean, that's what trial judges do in these cases all the time. I mean, you got to make a determination at the time of the final judgment as to which residence is going to be utilized for determination of the school. Of course, you don't know whether 5 years down the line or 10 years down the line, whether the school district is going to have a downturn or an upturn. But that's, you can't make a decision as a trial judge based upon those types of events. I mean, you're going to have people back in court, every 6 months, every year, even more than they already are. It just seems that that's an unworkable, and the policy considerations behind it don't make any sense.
I understand all of those arguments, Your Honors. In this particular case, what the judge did, the trial court did, was fashion a time-sharing schedule, and the time-sharing schedule and the school district are related issues, because where the child lives is going to affect whether or not the school issue works. So those are related issues. The main argument that we made was that the trial court made a decision based on time-sharing that used the crystal ball that's talked about in these lines, the Arthur case and its progeny, that she did that to decide what would happen in 2 years, literally 2 years, when the child was in kindergarten.
But that happens in every case. I mean, your timeshare, under your theory, if you have a child that is a year old or 2 years old, you can't make a determination as to what's going to happen when the child hits kindergarten. Is that the legal point? Is that the argument you're making? Is that a child preschool age child, that the trial court cannot make a determination as to what happens once the child starts kindergarten? Is that the legal point you're arguing here?
The legal point I'm arguing is the one set forth in Arthur.
No, I want you to answer my question. Can a trial judge take a pre-kindergarten child, someone who's 1, 2, 3 years old, and make a determination as to what happens once the child reaches school age? Yes or no?
May I ask for clarification? Does Your Honor mean what happens with time sharing?
What happens with where the child's going to go to school and alterations of time sharing, based upon the fact that the child's in school now, and whereas the child wasn't in school previously. A known event.
In the fact scenario of this case, no.
Well, you're qualifying it, and I'm asking you for a rule of law. Can a trial judge make a determination at the time of the final judgment on a 2 or 3-year-old what will happen when the child starts school age?
With regards to time sharing, Your Honor?
Regards to time sharing and with regards to where the child will go to school.
Only if it relies on information that it can state is in the best interest of the child at that time, that's not prospective, that's known
Of course it's
information.
perspective. The child isn't in school yet. The child's going to be in school in 3 years or 4 years. Of course it's perspective. By its nature, it must be perspective.
I would like to differentiate between the prospective nature of every single ruling that the court makes, because it applies in the future, versus the court making a time-sharing determination based on unknown future events. Those two things are different. I know that.
Also, I think the problem that I understand. I think I understand your argument. The problem I'm having is it's not a speculative event. I mean, this is, as Snowden said, this is the parties could reasonably anticipate that the child would go to kindergarten, and I mean the statute says the trial court has to make the schooling determinations. And so what I'd just like to hear is, in this case, what could the trial judge have done, in your view, that would have complied with the law? Given that the trial court had to determine schooling in the future, and we know for sure that's going to happen, what does the judgment look like in your view?
In my view, it looks like the mother has the majority of time sharing because the father and the mother live an hour apart. That would be the ideal situation because I've represented the mother.
No. Assuming the trial court believed that it was in the best interest of the child for schooling to happen in the father's district, school district. So at that point, what was the trial court supposed to do?
In my opinion, to answer the question fully, I think the trial court would have had to either give the father the majority of the time sharing and the school district, or give the mother same, or state with findings explaining why that the parties could do 50-50 an hour apart, and then the child will go to one school or the other. Those are the three things that the court could have done. The court could not take a misdirection in 2 years based on unknown future
So
events.
the court would have had to say, if the court believed that the child needed to be with the father at the time she starts kindergarten, then the court would have had to award majority time sharing to the father on day one. Is that your position?
Not necessarily, Your Honor, because the court, I have seen this many times because I wasn't the trial attorney in this case, but I have been in family law for 22 years. And so I've seen many cases where the court does find it's in the best interest of the child to do 50-50 when the parties are an hour apart. For example, in Orlando, if you...
No, assuming that the trial court did not believe it was in the best interest of this child to do 50-50 while she was in school, okay? Taking that as sort of the lay of the land.
Okay.
The trial court, in your view, the only option for the trial court was to award the father majority time sharing from day one. Is that your position?
Within that hypothetical, that would have to be the court's ruling, because the court cannot...
So should we remand for the trial court to enter an amended final judgment awarding majority time share to the father?
No,
Why not?
because it has been already 2 years since this trial occurred on January 7th of 2016, and this goes to the second argument in the initial brief.
You get a do-over. Your argument is you get a do-over, that back at the time that you filed the motion for new trial, that, I'm not talking now, I'm talking as of the time that you filed the motion for new trial, instead of simply correcting the judgment and perhaps granting the father, under your theory, the majority of the time sharing, your theory was that you get a complete new trial, all new evidence, you start over from ground zero, right?
That is my argument, and here's why, Your Honor, because number one, the trial occurred in January of 2016. The final judgment was entered in October of 2016. We filed a motion for rehearing, and that wasn't granted until already the beginning of 2017. Even when the court granted my motion for rehearing, even when that occurred, it had already been a year, and now it's been 2 years, and so yes, the court the court cannot assume that the circumstances presented at trial even apply anymore. And I think, and I don't know for sure exactly why the court did this, but based on the comments made and based on the actual order, it seems to me that the court could have done other things like strike some of the provisions, but the court didn't. The court said it, granted the request for a new trial.
So your argument's based, on that point, your argument's based entirely upon the amount of time that elapsed from trial to the rehearing?
No, Your Honor.
What else is it based on?
It's based on other factors like, number one, the court has the authority to order a new trial. So does the appellate court. Number
Well, no, but you're saying because of the amount of time that elapsed, now we have to start over. Is the fact that you have to start over with a brand new trial simply because of the amount of time that elapsed between the trial?
No.
What are the other reasons then?
When the court fashions a comprehensive final judgment, all of the parts are interrelated. The school district, the time sharing, everything is interrelated.
So you're telling me that if a court commits an error in some sort of time sharing, you've got to start all over, that the trial court should not just correct it, but you start the trial from scratch?
My point, Your Honor, is I don't know if the court can correct it because, number one, the court didn't.
Well,
The most compelling evidence that the court couldn't do it is the court didn't. The court, from my take on the comments, from my perception of the court's ruling and the comments of standing in that courtroom with the trial judge, is that the determination that she made was a bunch of moving parts like every case that she put together, and then if she changes just part of it, what if another determination was associated with the part that has to be undone? Then maybe those two
aware
things...
of whether this trial judge has done this in other cases?
Pardon me?
Are you aware of whether the trial judge has done this in other cases and granted new trials?
No, but I'm aware that the trial judge, I know that she feels this is an important issue, and I know that she gave a lot of thought to this based on her comments. And I've practiced in front of her for years, and I know that she went through the statute, and I know that she's very thorough. And my guess is that when a judge puts a final judgment together, that they don't just look at each part in a vacuum. I think that they probably fashion a ruling they think is in the best interest of the child, and I think that the best interest of the child, which is a standard, is not requiring us to take shortcuts and just take one little moving part off. I think the best interest of the child requires the trial court, if it thinks that it can't just get rid of one provision, to do a new trial.
So Robert, you agree that trial courts in these cases routinely make prospective rulings? You agree with that, don't you?
Not under the definition that's coming out of this line of cases, no. If I can explain, I think that all relief except retroactive child support and retroactive alimony, everything else is prospective. The problem is, in this case, like the JD versus JP versus DP case, in this case, the court actually addressed future factors. So in the main case that we cited and that the judge cited,
which was that the child was going to start school.
It's like the JP case. What's happening is the child was required to move a couple years after the case was done.
In the JP case, the child was already in school.
But
Not like this case.
But in the JP case, like this case, the child was required to move at a certain school age to another location, just like this case.
Well, this child is, going to, the time sharing's already where the father resides. The child's not moving out of state. You're not relocating the child. The child's currently exercising child visitation, or is time sharing is already occurring there. They're not moving. The child's already there. It's just an adjustment of the time sharing because the child's starting kindergarten.
The court can only adjust that time sharing on a modification action. The court, under Arthur and its progeny.
So you're suggesting then, what about the time when you adjust time sharing for summer visitation? Because the child is older. That's improper under your analysis, correct?
If the court said the summer will be like this for the next 2 years, and then it will change to something else, then yes, absolutely.
What about Snowden?
And you don't think that happens in almost every final judgment entered?
I've never seen it happen.
Counsel, what about our,
I've done 156 trials and I've
Well,
never
you
seen
know,
that happen.
and I've been around the block too, and the fact is that summer visitation routinely is altered depending upon the age of the child. That it might, you don't take a 1-year-old and give, and usually split the summers. That's not what occurs on a regular basis.
The thing is, Your Honor, that I know that the summer the number of weeks might change or something like that. But in this case, what changed is
But you're saying that that's improper.
it's improper if it happened in a way like I'm describing that would violate the Arthur case. I think this is a case about applying the law and the law.
Arthur is a relocation case. If you were a first-year law student and I asked you to give me the holding of Arthur, what would you say the holding of Arthur was?
That it prevents the court from using prospective, to make a prospective ruling on that case says on a relocation case.
That's
but-
the holding of Arthur. The
Yes,
holding of Arthur is a relocation case.
yes. However, Your Honor, the premise for Arthur is not something associated with the fact that it's relocation. It's something associated with the fact that it's looking into a crystal ball prospectively. So the holding in Arthur is not tied only to the relocation. There's no salient connection between Arthur's ruling and the fact that it was relocation. In my opinion, humbly and respectfully, that's why it's been applied. Arthur has been applied to alimony, child support. These are my brief. Other time-sharing cases like JP. So in my respectful opinion, I think that the holding in Arthur was not something inherent in the fact that it was a relocation case. It seems to be more focused on the time-sharing aspect of it, the best interest of the child, and the fact that it was a prospective determination.
Yeah, all right.
All right.
Thank you.
I have 14 seconds left. I will retire. Thank you very much, Your Honors. I appreciate it.
Thank you.
Counsel, what is, if the panel decides that this case should be reversed, in your brief, you discuss Van Schmidt, and I'm just curious, what would you suggest is the remedy? Do we send it back to the trial court with instructions to reinstate the final judgment? Do we send it back to the trial court for reconsideration of the motion for rehearing based upon the correct law? What's the remedy if we decide to reverse?
The remedy would be to remand with directions to reinstate the final judgment.
Van Schmidt seems to suggest, now that was in the context of a jury trial and manifest weight of the evidence, but Van Schmidt suggests that we should send it back, if it applies, to the trial court to reconsider the motion for rehearing and the motion for new trial based upon the correct law. Does that not apply here?
I think that either, I don't think that's necessary here because the court was very specific at the hearing on the motion for rehearing and considered these things. A lot of the conversations that we're having here, the court said out loud. She thought about these things. She knows that it's supported by substantial competent evidence. The only issue was that she believed that the law prohibited it. I don't think that it would be error to remand with instructions to reconsider based on the appropriate law, but I also think that.
But if she implied the correct law initially, I don't understand why we would do that. If she was right and Arthur didn't apply, then what would we be doing, what would we be accomplishing by sending it back and say, apply the correct law when she did apply the correct law?
Right. Well, exactly. That's why I don't think that it needs to go back because she applied the incorrect law. So if you're saying her basis was Arthur says we can't do this, so that's why we need to order a new trial. You're saying, no, that's not what Arthur says. Arthur just applies to relocation, so it's fine. She didn't grant it on a lack of substantial evidence. So because the case law says that it's only granted to the extent explained in the order granting new trial, and that basis is incorrect, then I think
She thought she had committed a legal error.
she did.
Right.
And this, to answer the question about whether this judge does this routinely, the skip in the kindergarten, the change of the timeshare that was directed at counsel, she does. This trial judge, until this case.
All judges do.
Right. I don't know if you need a case for that, because I've actually been on the other side and challenged this same provision in a different case here, and it was PCA. And so based on the perspective change in kindergarten it's a Walker v.
You would have had to
Giangrande.
cite that case in your brief.
Okay, sorry.
And it's a PCA, so I'm sure you didn't. So go, move on.
But I think the correct thing to do would be to send it back to the trial judge to reinstate the final judgment. I think that this is an attempt to get a do-over completely of the trial based on just an incorrect application of a relocation statute or a relocation case. I can see where arguably you can read that it applies to all types of cases, but if there's substantial competent evidence to support the trial court's judgment, that's a standard that has always been the standard. And the Supreme Court, they're pretty smart people, and when they made the holding in Arthur, they repeatedly said in relocation cases. I don't think there was one sentence where it says this is a standard and doesn't also say in relocation cases. So, for the foregoing reasons, I would request this court remand with instructions to reinstate the final judgment.
Thank you, counsel.
Thank you.
See, you didn't need to be nervous. Did you?